Hi, do you have clients that are still waiting on their employee retention credit refunds? If so, we are going to go through a few options that your clients may be able to utilize in order to get your refund sooner or process from the government at all. My name is Rebecca Shepard. I'm a tax attorney here at Frost Law. I'm here with my partner, Peter Huckabee, and we are going to go through the options that your clients may have. Recently, the commissioner has issued about 400,000 refund claims out of 1.5 million that were stuck. This is great news for taxpayers and that have been waiting for quite a long time to get these refunds paid, but it comes with some negative news. A lot of times, clients will file returns for 5 separate quarters, 6 separate quarters, seeking their employee retention credit refunds. But what's happening is the IRS is processing returns 1 quarter at a time. So a lot of Q2 2020 claims have been paid, which is wonderful news, but it means that taxpayers are waiting on Q3, Q4 of 20, Q1 of 21, Q2 of 21, if possible Q3 of 21, and those claims have not been processed as of yet. So what can a taxpayer do? What are their options? Peter, what would you tell them first?
Sure, so the question really is, do you want to try to do something administratively within the agency itself, or do you look for relief outside of the agency? Since we are starting to see only some of the calendar quarters be processed, we have yet to see, recently where a taxpayer has had all of their claims processed and received refunds. So some of the administrative options may be less attractive to taxpayers, and they may be seeking judicial review of these claims, and that is really what we're here to talk about today.
So what does administrative relief mean? It's going to the taxpayer advocate and trying to explain why your company is facing a financial hardship. So you want to talk to your client, find out the basis of their claim. Why are they eligible? Who made that determination? Was it a third party? Was it a company that calls itself 123 ERC? If so, you might want to dig a little bit deeper, make sure you understand the basis of the claim. Then you want to understand what is going on in the taxpayer's life right now. Are they taking out financing in order to fund payroll, in order to fund business expenses? If that's the case, then you have a financial hardship that the taxpayer advocate may be able to help expedite your claim. So what the taxpayer advocate does is it bubbles your claim up for the IRS for review. This can either kick it into an audit or it can kick it over to get processed. Once the IRS reviews it, then you'll know where you are with the claim, and at least you're going to start moving that claim forward, whether it's through an examination or it's through just the regular process of getting that claim paid. That process does take some time, but it is better for some folks than just waiting to see if and when the IRS will process their refunds.
The other option may be to work through a Constituent Services Offices with a congressman or woman. The challenge there is that oftentimes these services are also just employing the services of the Taxpayer Advocate Service. So it may not be a viable option or anything quickly, and so what taxpayers are starting to work through is whether or not litigation against the government makes sense for them. Rebecca and I are spending a lot more time these days with business leaders and decision makers within firms trying to decide if this is a good move for them. After 6 months of inaction or after a disallowance of a refund claim, taxpayers have a right to initiate federal court litigation against the government to force a court to review their claim and make a decision. What we're seeing in the ERC space is that is happening more and more frequently. So what you need to know and be able to communicate to your clients is that they have an option to initiate litigation against the government to force a court to review these refund claims. So something that involves significant decline in gross receipts analysis, or a situation where a government order very clearly closed a business. Those are great candidates for litigation. So the important takeaway is to know that your clients have the ability to initiate litigation against the government, a refund claim lawsuit, to force a court to review the employee retention credit claim itself, and to determine independently whether or not eligibility exists the computations are correct, and if a refund claim should be paid. Any claim that is under consideration for being filed in federal district court should be reviewed thoroughly. Part of what we do here at Frost is do a complimentary review to determine, the strength of your case and whether or not it is a good candidate for litigation.
So what do you tell your client that is waiting on their ERC refund and you don't know whether or not they're a good litigation candidate or a good taxpayer advocate candidate? Well, we are happy to perform a free case evaluation to make a determination of whether or not that claim is suitable for litigation. Not everyone is. And what does that entail? We will look at the revenue, we'll look at the PPP offsets, we'll look at the government orders, we'll look at the calculations, and then we'll do a comprehensive review, speak with the client, and make a determination of what are the best next steps forward. After we review the claim and do that complementary analysis, we'll work with you and your client to make sure that we are comfortable with the steps going forward. Clients are typically concerned about how much this is going to cost. Litigation can get very, very expensive. We handle this in a lot of different ways. Some folks want to pay hourly. Some folks would rather have a contingency agreement. Please let us know if we can help your clients. We're happy to talk to you, talk to your clients, and make sure that they get the refund they're entitled to. Thank you.